Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. We are talking about humanitarian reinstatements in this set of videos. We just did a video where essentially it was automatic to be able to continue with the petition if the petitioner had died and to get it approved unless there was specific briefs basically filed by the Secretary of State to deny it. But one of the main requirements was the physical presence of the beneficiary inside the United States already. So what happens if the petitioner dies and you're outside the United States, which is the vast majority of the cases? Well, let me read the provisions of law that deal specifically with that area, and then we'll go into some detail. Now, humanitarian reinstatement criteria, basically what it says is under prior law, the revocation was automatic due to the death of the petitioner, but under new provisions of the Code of Federal Regulations, USCIS, or the Department of State could grant a humanitarian reinstatement under certain conditions. And the factors that they look at are, one, the disruption of an established family unit, the hardship to the U.S. citizen or lawful permanent resident relatives, a beneficiary who is elderly or in poor health, a beneficiary who has had lengthy residence in the United States, a beneficiary who has no home to go to, or undue delay by INS or consular officers in processing the petition. Now, in this particular case, under what's called the Family Sponsor Immigration Act of 2002, certain relatives, such as the spouse, parent, mother-in-law, father-in-law, sibling, or child, if the child's at least 18, son, daughter, son-in-law, daughter-in-law, sister-in-law, or brother-in-law, grandparent, grandchild, or legal guardian, all of those relations, they may be substituted in to meet the affidavit of support requirements. So what becomes very important is to show that the beneficiary will not become a public charge. And so you need to have somebody who will sign the affidavit of support who makes sufficient money. And it does leave it wide open. There's a lot of different relatives there. Now, the I-130 beneficiary, which is the person who's still living, must ask the Attorney General to reinstate the petition, sorry, excuse me, and must demonstrate that he has a qualifying sponsor. Now, there's various arguments that could be made, even if you don't have a qualifying relative, but it does become more difficult at that point. Okay, more on the coming videos.